Hello students, I'm Marjina Sultana, an assistant professor from Interpersonal Law College, Greater Noida. Today we are going to do Principles of Natural Justice. Justice is the first and essential principle of an orderly society. The word natural justice is derived from the Roman word jus natural and lex natural, which implies fairness, reasonableness, and equality. There are three basic principles of natural justice. First, nemo debet esse, judex in propria causa, or rule against bias. Second, audi alteram partem, which means no man shall be condemned unheard. And the third principle is reasoned decision, or we can say speaking orders. Rule against bias is also means that no one can be a judge in his own case. So, when there is a dispute between two parties, the judge or deciding authority shall be an impartial third party. Bias literally means anything which tends to or may be regarded as tending to cause such a person to decide a case otherwise on evidence. A judge should decide the case solely based on the evidence available. He should be impartial. There are four kinds of bias. The first one is personal bias. Personal bias arises from a relation between the party, either of the party, and the deciding authority. So, such violation may be personal, fiduciary, or professional, and may be friendship or hostility. It means that if a person, if a judge is a friend to either of the party or is a relatives to the party, he may decide the case in favor of that party, his relative or friends. If the judge is an enemy to the party, he may be hostile against that party and decide the case against him. So it will be a bias on the part of the judge. The second kinds of bias is pecuniary bias. It means that the deciding authority will be disqualified if it has a, a financial interest in the subject matter of the litigation. No matter the financial benefit may be small or a very that be of very small amount. The third kinds of bias is subject matter bias. So this kind of bias arises where the judge or deciding authority is interested in the subject matter of the litigation. So the deciding authority is if interested in the subject matter, then he may be, he may not be impartial. There may arise a conflict between his duty and the interest in the subject matter under the circumstance. For example, let's presume that the judge or deciding authority is environmentalist. He is more interested in, he has more concerned about, and he's more concerned about environmental issues. Then in environment related cases, he may decide the case based on what he believes. Okay, it may be, he may never be, against his belief. He may decide the case according to what he believes, so it will not be impartial. it will be against it will be a against the rule against bias. The fourth kinds of bias is departmental bias. So this kind of bias arises when the judge is acting in extreme departmental influence. So this kind of bias is very common in executive process. So the judge or deciding authority may try to uphold the policy of the department. Audi alteram partem or rule of fair hearing. Audi alteram partem simply includes three Latin words which basically means that no person can be condemned or punished by the court without having a fair opportunity of being heard. So this fair hearing must not be of mere formality. So according to this rule of fair hearing, there is there are some components of rule of fair hearing. It includes notice, issuance of notice. So the parties should be aware about the thing he has been charged. The second component is right to present the case and evidence. After receiving the notice, the parties receiving the notice must be given a reasonable time period to prepare and present his case in a real and effective manner. The refusal should not be done on the unreasonable ground or due to arbitrary reasons. The third component is right to cross examination. uh, right to cross examine the statement made by the parties, nature of the act, etc., to cross examine the witness and the evidences. The fourth component is right of legal representative. So, so the parties to the conflict dispute should have the right to be represented by a professionals by an advocate of his choice so that he can be represented in an effective manner. So this principle of fair hearing or audi alteram partem infers that the person against whom any action affecting his rights is to be taken should be given reasonable opportunity to defend himself. The third basic principle of natural justice is reasoned decision, or it is also known as speaking orders. This principle is based on the rule of law that the judges shall act according to the rule of law and they are bound to explain why and on what reasons he or she decided the matter in a particular way. So along with the other principle, that is being impartial and observant of fair hearing, the judges must also provide reasons for his decision for the simple reason that reasons are the link between the order and the mind of the maker. Or we can say this reasoned decision is important. The responsibility to record reasons works as obstacles against arbitrary action by the judicial power vested in the executive authority. This reasoned the rule, the principle of reasoned decision the responsibility to provide a reason for arriving at the conclusion works as against the arbitrariness, against the arbitrary decision of the judge. So all these three basic principles is to uphold the rule of law and to provide justice, to provide natural justice. The principles of natural justice are included in our Constitution of India. Some of the provisions of the Constitution which are considered as embodiment of natural justice are, for example, preamble to the Constitution of India provides to secure justice. Justice is social, economic, and political justice. It also provides to secure liberty of thought, expression, belief, faith, and worship. Article 14, which provides about equality, strikes at the root of arbitrariness. Article 21, protect liberty and ensure life with dignity. Article 22 provides principles of natural justice which has provision of fair hearing. Article 39A provides for free legal aid to the indigent persons and also for the disabled persons. Article 311 provides constitutional protection to civil servants. And lastly, Article 32, 226, and the 136 provides constitutional remedies in cases of the violation of any of the fundamental rights, including principles of natural justice, through judicial review. So today's discussion ends here. Thank you for watching on the video on principles of natural justice. Thank you again.